Service of process. Pursuant to Rule 3.110 of the California Rules of Court, a copy of the complaint and summons must be served on all defendants within 60 days of the filing of the complaint in California Superior Court. If the documents are not served within 60 days, the plaintiff may be sanctioned and risk the case being dismissed for failure to prosecute at the discretion of the court. Pursuant to California Code of Civil Procedure Section 583.210, the documents must be served within 3 years or be subjected to mandatory dismissal. Moreover, a proof of service must be filed with the court within 60 days from the date of service. Pursuant to subsection M of Rule 4 of the Federal Rules of Civil Procedure, the plaintiff must complete service upon the defendant within 120 days after the filing of the complaint. If the plaintiff fails to provide service within 120 days, the defendant may motion to have the complaint dismissed for improper service. Service of process gives the defendant the legal notice that a civil action has been initiated against them. The summons gives the defendant instructions to respond to the complaint within 30 days in California Superior Court and 20 days in federal court. In all cases, the process server must 1. Be 18 years old or older, 2. Not a party to the case, 3. Serve the paperwork on the other side in the time required, 4. Complete a proof of service describing who was served, when, where, and how, and 5. Return the proof of service to be filed with the court. The plaintiff or defendant cannot serve their own papers. However, the party's attorneys may serve the documents as the attorney is not considered a party to the lawsuit. Service of the documents can also be done by the sheriff, marshal, registered process server, or by any other person older than 18 years old and not a party to the action. When hiring a registered process server, provide a photograph of the person to be served and a list of times and places to find the person. Process serving fees are often based on travel distance. It is best to use a process server located near the person to be served. Personal service. A person who is not a party to the case must personally deliver the court documents to the other side. The service can take place at any location. The server has to 1. Identify the party being served, 2. Hand deliver the legal papers, and 3. Inform that they are court papers. If the party served refuses the papers, the server can simply leave the papers on the ground in front of the party. The process server must complete a proof of service detailing when, where, and how the papers were served in person. The proof of service must be signed and filed with the court. Personal service is the most reliable type of service because the server can testify that the person being served, in fact, received the papers and had notice of the lawsuit. Personal service is accepted in all cases and is generally required when serving the complaint. Service by mail. A person who is not a party to the case may send the documents by first-class mail to the other side. The papers can be mailed to the party's home or mailing address. If the other party is a business, the papers must be mailed to the owner at the business address or to the agent for service of process. The proof of service must state to whom the papers were mailed, to what address, when, how, for example by first-class mail, and where they were mailed from. Service by mail is complete 5 days after the papers are mailed. Mail service is not a reliable method because the court cannot determine whether the other side in fact received the papers. Substituted service. If personal service is not successful, the other side may be served by substituted service. After 3 reasonable attempts to personally serve the papers on different days and time, the server may leave the papers with someone at the other party's address who is at least 18 years old and lives there. If attempting service at a business, the papers must be left with someone at the office who appears to be in charge and is at least 18 years old. In the proof of service, the server must include the name and address of the person who received the court papers. If the person refused to give their name, the server must provide a physical description. In addition, the server must mail a copy of the papers to the other party at the address where the papers were left. Substituted service is complete 10 days after the date of mailing. Furthermore, the server must file with the court a declaration of due diligence detailing the attempts to serve the papers in person, including the dates, times, address, and a description such as no one answered the door or the party not in the office. The declaration is signed under penalty of perjury. Substituted service is not a reliable method, as it is not certain that the papers were in fact received by the person to be served. Service by notice and acknowledgement of receipt. If the other side agrees to service, a signed notice and acknowledgement of receipt for the documents is sufficient. Once the acknowledgement is signed, then papers must still be served by mail, including a signed copy of the acknowledgement. A proof of service is then filed with the court. Service is complete on the date that the acknowledgement is signed. Service by publication. When the other party cannot be located, service by publication is a permitted method in which the summons and complaint is published in a newspaper of general circulation in the area where the other side is likely to be. The court must grant permission to allow service by publication, which is requested by an ex parte application attached with a proposed order. A declaration of due diligence must also be filed with the court, which details the attempts to find the other party. The plaintiff must at least try to find the other party at his or her last known address or last known work. Mail letters to the last known address with forwarding address requested. Call the other party's friends and family or ex-co-workers to ask about his or her whereabouts. Look for the other side in the phone book for any city where he or she is likely to be, and search on the internet. The declaration of due diligence is signed under penalty of perjury. Once permitted by the court, the summons and complaint must be published for 4 weeks consecutively, at least once a week. The newspaper must provide the plaintiff with an affidavit showing the time and place the documents were in fact published. Service by publication is complete at the end of the 28th day after the first date the summons and complaint are published in the newspaper.